Thanks, Anthony. Well, joining me this afternoon live from Los Angeles is Francey Hakes, a former federal prosecutor, and she joins us via Skype this afternoon. Hi there, Francey. Thanks for being with us.
Hi, Stacey.
So let's talk about this case out of Wisconsin. I mean, it seems pretty open and closed given the fact that there was police body cam footage showing this attack on the police officer during the traffic stop, right? I mean, that seems to be the proof in the pudding, literally.
It does, Stacey. You know, I'm always distressed, though, when we see just these small clips of what happens on the body cam, because these encounters are always much longer than that. A traffic stop in and of itself happens when the cameras are turned on, usually when the police activate their lights and sirens. And so I do want to see the full encounter, but as we've seen from the clip so far, it certainly looks open and shut that this offender, Zelmer, attacked the deputy sheriff with absolutely no cause.
Yeah, I mean, it's a good point. Often we do see an edited clip of this surveillance footage, body cam footage, dash cam footage, in this case presented by police, so we don't really know exactly what led up to the altercation. Now, it's possible, you know, I suppose police, you know, were maybe a little bit aggressive with him or provoking him, but even if that were the case, does that really matter? I mean, he's still seen basically assaulting the officer, and the officer was taken to the hospital.
No, I mean, there's certainly never an excuse for assaulting a police officer. All I'm saying is, as you noted, we just don't know what happened first. And I always want to know what precipitated an encounter. One of the things, Stacey, that I wonder if you noticed I thought was so interesting in this video clip is the offender's, Zelmer's eyes as he comes out of that car. He looks mean and angry, in my opinion. And so it doesn't look as though there were any excuse that's available to him here. It does look like a clear case of a drunk guy assaulting a police officer, but I still want to see the whole thing.
Yeah, well, I mean, the good news, the officer suffered a knee injury, nothing too serious. He was back on the job. Meantime, Zelmer due back in court later this week. Okay, Francey, thanks for the analysis on that. We're now going to go back to the Shawn Grate trial, the murder trial out of Ohio that we have been revisiting all day. Now, Shawn Grate faces 23 counts, including murder of 2 women and also abducting, kidnapping, sexually assaulting this third woman, Jane Doe, who managed to escape. While Grate was sleeping, she claims she was able to grab his cell phone, call 911, and get authorities to the house, who eventually did rescue her. At that point, police then found the 2 dead bodies of the other victims in this case. Now, those women are Stacey Stanley and Elizabeth Griffith. We've been revisiting the trial all day long, as I said, and coming up in just a little while, we are going to have the verdict. We'll find out whether or not jurors decided that Shawn Grate is guilty of these crimes or not. But for now, I want to go back into the courtroom because we're in the midst of perhaps what is some of the most compelling testimony of this entire trial. We are hearing from Jane Doe about her horrifying days being kidnapped, held hostage inside Shawn Grate's home as he sexually assaulted her, as he raped her, as he tied her to the bed. So let's go back now inside of that courtroom and hear the rest of her testimony. Welcome back to the Law and Crime Trial Network. I'm Stacey Delikat. All day long, we have been revisiting the high-profile death penalty trial against Shawn Grate. He is the Ohio man who prosecutors and law enforcement allege is a serial killer on trial for murdering 2 women, storing their decomposing bodies in his basement, and also charged with abducting and kidnapping, sexually assaulting a third woman who was able to get away. While he was sleeping, she was able to reach for his cell phone after days of being held captive in his bedroom and being sexually assaulted. She was able to reach for his cell phone as she slept and call 911. Police did arrive at the house where they were able to rescue her and find the 2 bodies of the other women. Well, we have just been listening to testimony from that Jane Doe. We have not been showing her face to protect her privacy. Francey Hakes, federal former prosecutor, with me live via Skype from Los Angeles. When you have such compelling testimony like this, Francey, when she's talking about the horrors she suffered at the hands of this man, when he said, "Have you had enough?" You know, after sexually assaulting her and raping her for days, tying her up. I mean, that is powerful stuff for a jury to hear.
It is powerful stuff, and it's unusual, Stacey. It's one of the things that makes murder cases actually really hard generally, because the jury literally never gets to hear from the victim. They see the live, normal-looking defendant sitting in the courtroom, and the victim almost becomes a non-person to them. But here, you have a victim, you have a survivor who has been in that house of horrors, knows exactly who Shawn Grate is, and can really describe to the jury the brutality with which he treated her. And that's critical evidence in this case.
Yeah, I mean, I think without question, this is prosecution's star witness. And as I said before, some of the most compelling testimony we hear in this trial. I mean, it's hard, you know, just obviously looking at this piece of the trial to imagine, you know, why jurors wouldn't believe her, especially because Shawn Grate's team didn't even give an opening argument at the beginning of the case. Do you know, find fault with that?
No, you know, I think, Stacey, this case is interesting because 2 dead bodies were found in his house. He has no real defense. He has no defense for that. He has no defense for the Jane Doe testimony. So I think this case is all about trying to save his life. It is simply about his defense attorneys trying to make arguments that will humanize Shawn Grate so that the jury will not impose the death penalty. This case is not really about guilt innocence, because there's just no way he's getting out when they found 2 bodies in his house.
Yeah, and I mean, defense have said as much. They know he's gonna, you know, serve time for something. He's not getting away. Let's go back into the courtroom now and listen to some more of that testimony from Jane Doe, and then we'll come back and discuss some more. Well, there you heard some more horrifying details from the Jane Doe in the Shawn Grate murder trial from his victim, who was able to get away, talking about how he sexually assaulted her, raped her, at one point put makeup on her, and did a few other strange things. Francey Hakes, federal former prosecutor, still with me live via Skype. I want to talk about one other aspect of this case, Francey, which is that Shawn Grate basically confessed to police when he was first arrested. He also wrote letters from jail to reporters detailing what he had done and basically saying that he killed these women because the state had already killed them. He was just taking their bodies. When you have like these confessions already out there, you know, what does... You talked about it before. I mean, this isn't about proving, and we know it's not a whodunit, you know, but how tough is this for defense attorneys?
Well, Stacey, that's a great point. It's really hard for defense attorneys when they have a client who's confessed and they have a surviving victim. But that's their job, and their job is to simply save him from the death penalty. That's their goal. That's their entire defense strategy at this point, will be to save him from the death penalty. And this testimony that we've been listening to from Jane Doe is incredibly powerful. And it also really speaks, I think, to dehumanizing Shawn Grate. If you think about the things that Jane Doe is talking about him doing, putting on makeup, shaving her pubic area in the shape of a heart, this is clearly a man with a dangerous obsession, and the jury's definitely going to see it.
Yeah, although, you know, we do know that his defense team at one point did, you know, try to argue for the judge to, in front of the judge, you know, to be able to use a mental, an incompetence defense, but that was rejected. So, yeah, this is clearly, though, a man who has some very strange, disturbing tendencies, that is for sure. We're going to take a quick break. When we come back, we're going to have much more from this death penalty trial of Shawn Grate that we've been revisiting all day. We'll be right back. We've been listening to Jane Doe on the stand in an Ohio courtroom where Shawn Grate was facing murder charges, the death penalty for murdering 2 women and kidnapping, holding hostage this third woman, Jane Doe. We were not showing her face to protect her privacy. Francey Hakes, federal former prosecutor, still with me via Skype from Los Angeles. It's really emotional testimony to hear from this woman. I mean, you can only imagine what this woman has been through. And you would think that prosecutors, you know, would let her tell her story, but really they are doing that. They're also going through very meticulously, like with a fine-tooth comb over each and every detail. And Francey, you were explaining to me during the break that that's really essential for proving their case, right?
It is, Stacey. Prosecutors have to prove every element of the crime. So they have to prove that the sexual activity, such as it was, we know it was rape, but sexual activity was without her consent. So while it seems obvious, he kidnapped her, he kept her bound sometimes, he was doing things against her will, prosecutors still have to ask what probably seemed to the jury to be dumb questions about whether or not she actually consented to being raped. And so, of course, her answers are, no, I didn't consent. But those things are required because prosecutors have to prove each and every element of every charge.
Right. I mean, she has to clearly state that this was done to her and this was not something she wanted. You know, we know the defense is not trying to argue that he didn't do it, but they could have said, you know what, it was some of the sexual stuff was consensual. They could have argued that had she not made that clear.
That's absolutely right.
Yeah. Francey, we're going to take a quick break, but when we come back, there was a little bit of a twist in this case when Shawn Grate decided to take a plea on some of the charges. We're going to tell you which one coming up right after this break. Be sure to stay with us. We'll have the verdict shortly after that. Well, there you have it. Midway through his trial, Shawn Grate decided to plead guilty to 15 lesser charges that he was facing. Those charges included, as you just heard, gross abuse of a corpse, burglary, rape, multiple counts of rape, multiple counts of gross abuse of a corpse, unauthorized use of a vehicle. Now, Shawn Grate claimed he was taking these guilty pleas so that he would make it easier on his victims. He wouldn't rub the crimes in his face. But there's talk that, it came out in court that actually he pled guilty on these crimes to avoid some videos being released into evidence, so-called rape videos, which detectives said included video of him raping some of his victims, including one of the murder victims. Francey Hakes, federal former prosecutor, still live with us via Skype from Los Angeles. First of all, are you surprised at all that he decided to plead to these charges, to these lesser charges halfway through the trial?
No, not in this case, Stacey. I mean, this is a death penalty case, and his attorneys are trying to save his life. So this is actually a clever tactic. It's going to allow the defense attorneys to argue during the penalty phase that Shawn Grate has admitted responsibility for what he did. You can trust, ladies and gentlemen of the jury, that he has been rehabilitated. He has learned from his mistakes. He has accepted responsibility for his actions, so you don't have to fear that he would ever do something like this again, so you don't have to give him the ultimate punishment. And one other quick thing, Stacey, that's interesting is he had to admit to these special enhancements of being a sexually violent predator. And those are really key enhancements because, one, they probably bring sentencing enhancements, that is, higher penalties. But two, I suspect that Ohio has a civil commitment law. What that means is even if by some miracle Shawn Grate were to ever get out of prison, he would be civilly committed as a sexually violent predator indefinitely and monitored by a judge and a prosecutor and doctors to say he has to be incarcerated until and unless he's no longer a sexually violent predator. So those were key pleas.
Yeah, I mean, do you think that it's, you know, when it comes to defense attorneys trying to stave off the death penalty, that helps because jurors can say, well, first of all, in this case, these lesser pleas, the penalty is 72 years to life in prison. So there's very little chance just on these charges that he would ever get out of jail. So when, you know, defense attorneys are trying to save their client from the death penalty, you know, how much does something like this, you know, in your experience, comfort jurors to think, okay, well, you know what, he's not getting out anyway. He's going to be behind bars. He's going to be a predatory sex offender, as you said. So, you know, he'll pay the price for what he did just on that alone. Is that, you know, what they want jurors to think?
Yeah, and it can be persuasive, Stacey. I mean, it's one of the hardest things about the death penalty is convincing a jury that death is the most appropriate punishment and not, for example, life without parole. It's a real challenge in these cases to convince a jury to weigh and to impose the ultimate punishment when life without parole is available. And things that jurors don't know is that
Francey, I got to cut you off there. Hold that thought. We're going to be right back after this break with much more on this trial and Harvey Weinstein. Stay with us. Welcome back to Law and Crime. I'm Stacey Delikat. We are getting close to a verdict in the Shawn Grate murder trial. We've been revisiting highlights from that case all day. Shawn Grate on trial for the murder of 2 women and for abducting, kidnapping a 3rd woman, raping her, holding her hostage for several days until she was able to break free and call 911. We just finished listening to some of her testimony as she recounted to jurors the horrors she experienced at the hands of Shawn Grate. In just a little while, we are going to play you the verdict on whether or not jurors found Shawn Grate guilty, and then we will let you know whether or not they decided that he should get the death penalty. But we want to take a quick break to talk about another big legal story in the headlines today, and that has to do with Harvey Weinstein, the disgraced movie mogul, back in court today facing more sexual assault charges. Anthony Velez has a summary.
Here is a quick Law and Crime breaking news update. Disgraced Hollywood producer Harvey Weinstein was back in court today in New York City and pleaded not guilty to new sexual assault criminal charges. Manhattan prosecutors charged Weinstein with 1st and 3rd degree rape in one case and a 1st degree sex act in a second case back in June. And Weinstein now faces 2 counts of predatory sexual assault for an alleged incident in 2006. Weinstein has been accused by 80 women, including A-list actresses, of sexual misconduct. The allegations against Weinstein helped to launch the hashtag #MeToo movement on social media, encouraging victims to tell their stories of sexual harassment and abuse. Weinstein is also under investigation in Los Angeles and London for alleged sex crimes. I'm Anthony Velez, and that was a quick lawandcrime.com news update.
Well, prosecutors say that Weinstein faces some of the most severe sex crime charges there are. And because of the severity of these new charges, the assistant DA handling this case asked the judge this morning that Harvey Weinstein be restricted to staying in his house or apartment in Manhattan. The prosecutors wanted him to stay in New York City until his next court date because they said he has resources and he could flee. Now, the judge denied that request, but Francey Hakes, former federal prosecutor, still with me via Skype. What do you think about that request? He's already wearing an ankle bracelet. He's already been ordered to stay between New York and Connecticut, where he has another home. Are you surprised that the prosecutors wanted him confined just to New York City, to Manhattan?
No, and actually, Stacey, I'm surprised he's out on bond at all. This is an incredibly serious case. He faces so many sexual assault charges that he could very well be looking at a life sentence, even in New York, which is notoriously soft on sentencing, and he should be in jail, just like most offenders in his position should be in jail. But because he has money and resources and a high-priced defense attorney and a great team behind him, he was able to convince the judge to allow him out on bond. I think it's wrong. I think he should be in jail while he awaits trial.
Weinstein's attorney, Benjamin Brafman, and others acknowledged that there could be more charges coming forward soon, and that is something that the Manhattan DA has said, that it is not too late for survivors to come forward, that they are continuing to review cases. Do you see this continuing? Do you see this as, you know, month after month we hear of new indictments, new victims coming forward? Because I will say, in court today, prosecutors asked for protection of 2 other witnesses who could potentially come forward.
It is possible, Stacey. I mean, this guy was such a prolific serial sexual predator that there, over a period of, 40 years anyway, there could definitely be hundreds of women who, because he is now under indictment, because there's some chance that he could never hurt them again, they may feel comfortable to come forward. But you can see from the look on his face as he sits in court that he's arrogant, that he doesn't think that he is ever going to pay the price for his crimes. It's really the same attitude that he had throughout his life that gave him the thought in his mind that he had the right to touch women and assault women whenever and wherever he pleased.
Well, how about this for what some people might consider to be arrogance? Weinstein's attorney was asked, what is Weinstein doing now anyway these days, right? I mean, he's lost his company, he's lost his family. We know at one point he was in and out of sex rehab. But Brafman told reporters that Weinstein is acting as a paralegal to him, helping him do research to dig up dirt on the accusers. He says to come up with evidence and witnesses that will prove these encounters were consensual. What do you make of that? Harvey Weinstein now acting as a paralegal in his own case?
Stacey, this is so classic. This is what I would, if I was doing an opening statement in this case, the first words out of my mouth to a jury would be, this is a case about control. A man who had to control everyone and everything around him. And that's exactly what he's doing now, acting as his own paralegal or researcher. He still needs to feel that he is the one in control. And it is perfectly illustrative of the way he treated women and people who worked for him throughout his career. He was in control.
Not only did his attorney, Ben Brafman, say that he is working Weinstein's working as his paralegal, helping to dig up dirt on the case and the accusers, but he also said that he's trying to pursue film projects still. He said he is a brilliant maker of movies and scripts, is trying to pursue other projects. There was some talk at one point that Weinstein might be working on a documentary about the opioid crisis. I mean, what do you make of that? And does that play any part in this case, or, you know, in the ongoing investigation, what he's doing now? I mean, surely it could play a role in, you know, there's a question as to whether or not people will support him financially and otherwise, but does that make any difference in the investigation here in the criminal cases?
Yeah, Stacey, I don't think it makes a difference in the investigations. I think it just shows the investigators, the prosecutors, and the judge the kind of person that they're dealing with. So they will understand thoroughly who Harvey Weinstein is and how he behaves. That could have an impact on the investigation in the sense that it gives them clues that they may pursue because of how he's acting now. But I think more importantly, it simply shows us, a jury and a judge later in what I hope will be a sentencing of him, the kind of personality he is and why he's a dangerous man who will never truly accept responsibility for his heinous criminal actions.
Gloria Allred, obviously high-profile attorney for a lot of women in a lot of different cases, representing the woman at the center of this case today, whose identity has not been revealed. Outside court, she said of Brafman's argument that they were going to be able to prove that these sexual encounters were consensual. She said the only way that Weinstein would be able to even possibly convince jurors this would be consensual is if he were to take this stand. Do you agree with that? And what do you think about Weinstein possibly taking the stand in this and the other case against him?
Well, I think that his defense attorneys, Brafman's a very smart lawyer, and I think he's not going to want Weinstein on the stand unless he absolutely has to testify. But I do think that Weinstein's the kind of client who will feel, because he's so arrogant, that he can persuade the jury that all these women are lying. And let's remember an important point. It is unlikely that every one of these women who's come forward will be allowed to testify in a trial unless their encounters with him, their non-consensual encounters with him, are similar enough to the crimes that are charged to be brought in as prior bad acts or similar transaction evidence. So the jury is not going to hear a parade, I don't think, of 100 or 200 women. They will hear from a few key women and key stories, because there's no way the judge is going to allow that many women to testify because of the rules that say evidence cannot be more prejudicial than probative. So the judge will sift those cases very carefully before deciding which ones to allow in.
Is that similar to what we saw in the Cosby case when we saw several women testify in that second trial against him?
Yes, exactly. There was no way the judge could let in every single bad act allegation against him. Instead, it had to be ones that were similar enough to Ms. Costanza's case to make sense to the jury and be probative in a legal respect.
Going back briefly to what Brafman said about Weinstein acting as Brafman's paralegal, helping him to do research in this case, he said after 5 weeks of investigating with his client essentially serving as his paralegal, that they've come up with evidence to support Weinstein's claim that these acts, the sexual contact, was consensual. And he didn't provide many details, but he said that there were witnesses and emails. Is that viable, that maybe, you know, Brafman will produce some emails that show, look, these women emailed Weinstein. They wanted to set up meetings with him, and they were interested in a relationship with him?
Well, you know, Stacey, I don't doubt that they're going to have emails. There may even be emails that are inconsistent with what people think is the way a rape victim should act. But rape and sexual assault are very complicated crimes, and you're talking about a man who had tremendous power in Hollywood to make or break people's careers. So I won't be at all surprised to find that there may have been communications with some of his alleged victims that show that they were still, after alleging that he assaulted them, still trying to engage in some kind of professional relationship with him. This case is going to be so ugly. These women are going to be dragged through the mud. It's classically why rape victims come forward in such small numbers. Less than half, generally, of women who've been sexually assaulted come forward to the police, and minute numbers after that ever actually see a prosecution and a conviction. So this kind of drag victims through the mud, blame the victim, make the victims the ones who have to go on trial is a classic tactic by Ben Brofman and others, and it's going to be no holds barred, and it's going to be really ugly.
Yeah, I don't disagree with you. However, in this case, more so even than the Cosby case, I would argue these women, these victims, have a whole army of Hollywood women behind them who have come forward publicly and said this happened to them too. And so at least there will be that very, very vocal public support. Again, I would say more so even than in the Cosby case, because you have so many high-profile women who have come forward saying that they were in similar situations with Weinstein.
Yeah, I think that sort of sisterhood, Stacey, is going to be very important to support these victims that have come forward and that have to go through the bruising process of testifying and talking about the most difficult days of their lives. I hope that those women are supported in that way that encourages them to be able to do it and to be able to withstand that kind of brutal assault that they're going to find in the courtroom.
Yeah, well, we will have to wait and see. Weinstein will be due back in court soon. Of course, we will be following this as it develops, and it will continue to develop, I'm sure. Francey, thanks for your analysis on that. We're going to take a quick break. When we come back, we're going to have the verdict in the Shawn Grate murder trial. Stay with us. Okay, so that was some testimony from Shawn Grate's sister during the sentencing, the penalty phase of this trial. Defense attorneys trying to show that Shawn Grate had a very difficult childhood. We heard his sister talking about abuse at the hands of his father, fights between her mother and their father. Clearly not a great upbringing, clearly some trauma going on in her childhood and likely Shawn Grate's. Francey Hakes, former federal prosecutor, still with me via Skype. Francey, we hear this a lot, right? When it comes to sentencing time, defense attorneys will say, but they had this terrible childhood. They had this terrible background upbringing, and that has some way contributed to the defendant's behavior. Does it work?
Stacey, this is classically called the abuse excuse, and it is so frustrating for me still to listen to something like this, because it shows how fundamentally unfair to the victims and to the state this kind of testimony always is in death penalty cases, because the judge allows the defense attorneys to bring in testimony that cannot stand scrutiny. You heard her, for example, talking about something that clearly happened to her mother before she was born at the hands of her grandfather. That is classic hearsay evidence that she has no basis and no legal basis to be allowed to testify to in court. But the judge is allowing her to do it anyway because the judge doesn't want to get reversed on appeal. So letting the defendant get away with this kind of testimony is classic. And the state will not, when they put up victims' families, will not be able to get away with the same level of hearsay.
Yeah, I mean, you know, my thought is always, well, a lot of people have tough upbringings. A lot of people suffer abuse at the hands of parents or relatives and have a lot of trauma from their childhood, but that doesn't mean they are going to go kill someone or that they do go kill someone or hurt someone.
No, and it's very important to know that statistics tell us that children who are physically or sexually abused as children are no more likely to become abusers than the general population is, percentage-wise. So this abuse excuse, I prosecuted as a specialty child abuse my entire career, and I would get very angry when I hear defendants who have done horrific things blaming their childhood for why they have become a serial killer, when most children who experience this certainly do not.
Does this abuse excuse, I mean, is this always just kind of a last-ditch desperation effort? We gotta show something here, you know, to make jurors feel bad for the defendant?
It is. You've got to paint the defendant in a way that makes the jury feel sympathy for him. Because the theory goes, if the jury feels sympathy for the defendant, they're far less likely to impose the ultimate penalty, that is, impose a death sentence. And so the penalty phase is all about the prosecution showing evidence in aggravation, what a horrible crime this was, what obvious lack of feeling the defendant has, what a terrible human being he is, and it is shown through his actions, versus the defense having their evidence in mitigation, that is, portraying the defendant in the most sympathetic light possible, and that's what they're doing here.
Francey, thanks for that. We're going to take a quick break. When we come back, we'll hear a little bit more from Shawn Grate's sister, and then we will find out whether or not the jury decided he should get death. Stick around. So there we heard more from Barbara Charter on the stand. That's Shawn Grate's sister, and prosecutors asking her, well, you turned out okay. You did pretty well for yourself considering the abuse you suffered as a child. Your children are okay, right? She acknowledged, yes, that was the case. Francey Hakes, former federal prosecutor, still with us. This is what we had just talked about before the break. Just because Shawn Grate may have had a tough childhood does not mean that that should have caused him to murder women. We are going to play the sentencing in just a moment, but any final thoughts you want to share before we do, Francey?
Yeah, it's interesting. I thought that the prosecution did a great job just asking a few key questions, reminding the jury that just because you have a tough childhood doesn't make you into a murderer. But the prosecutors have a difficult job because they're not allowed to tell the jury that a governor could pardon him later if he gets a life without parole sentence, or that his sentence could be commuted, or that he could even escape because death penalty or those on death row are kept in much higher security conditions than other inmates. So the prosecution's job is still difficult, even in a case like this, because you never know when one juror might decide that they just can't impose the ultimate penalty.
Yeah, and it can hinge on just that. All right, well, it's time. Let's go now and listen to it. Did the jury decide Shawn Grate should get the death penalty or not? Well, Shawn Grate relatively emotionless as the judge read the jury's decision that he should get the death penalty. The judge later affirming that decision. Francey, what happens next? Because we know in death penalty cases especially there are appeals, right?
Yes, unfortunately, the death penalty takes far too long to impose. It's certainly not truth in sentencing, and it's probably going to be 20 years or even 30 years after lots of appeals, both in the state system and in the federal system, that Shawn Grate will have the opportunity to challenge this conviction. And one day, maybe, the death penalty will be imposed.
Yeah, I mean, and that would be the case, you know, the appeal would be the case even if he had gotten life without parole, I assume. I want to ask you one more question. Shawn Grate has been tied to 3 other murders that were not part of this case at all, and investigations are currently ongoing about those murders to determine whether or not he is responsible. He already has the death penalty, so if he is charged in these other murders, then what? You know, could he get, what kind of sentence could be imposed on top of the death penalty, if any?
Well, I think those cases are in another jurisdiction, and so one of the things that other jurisdiction has to decide is should they, since there has been a death penalty verdict in this case, should they go through the difficult time and expense of a trial in order to vindicate the interests of justice and the interests of those victims? I would not be surprised to see another jurisdiction try him really more for a safety net than anything else, just in case there were legal errors in this case and his death penalty and even his conviction get reversed. He has those convictions, presumably, in another jurisdiction. So it wouldn't surprise me to see them pursue it.
Yeah, you are right. That is in another jurisdiction, in another county. I mean, also, I would assume perhaps families or friends of those victims would like to see a little justice as well.
That's right. I mean, the interests of those victims were certainly not served in this trial. No one's even spoke their names. And so it's understandable that friends and family would want to see their interests vindicated. And it'll be very interesting to see if the prosecutors and the investigators in those jurisdictions or that jurisdiction make that decision.
Francey, I know, you said prosecutors can never be too sure when it's a death penalty case, and it couldn't come down to one juror who feels strongly. But were you at all surprised that the jurors in this case did opt for the death penalty?
I wasn't surprised, but I certainly wouldn't have been shocked if they hadn't, because as I said earlier, Stacey, it's just a very difficult decision for 12 people. It's hard to get 12 people to agree on what that
anything.
Much less the death penalty. So I wasn't shocked, but I think it seems to me to be the right decision. And I think all the evidence in this case pointed to Shawn Grate as a bizarre, cruel, dangerous serial killer. And if ever there was a case for the death penalty, this was it.
Yeah. Apparently the jury agreed with you, as did the judge. So I want to thank you for your analysis on this, Francey. We do have one more trial to talk about before we wrap up for today. But before we do that, let's go ahead and review today's top crime stories once more. Well, there you heard Anthony say it. The defense plans to use involuntary intoxication. They plan to argue that Collie was under the influence of Ambien at the time. Francey Hakes, former federal prosecutor, still with us in the home stretch here, joining me via Skype. What do you think about this Ambien defense that he murdered two people, including his estranged wife, because he took a sleeping pill?
Well, Stacey, we've heard this before, right? We've heard the Ambien defense in several cases. In fact, I remember one not too long ago of a congressman who I think crashed his car on Capitol Hill and fled the scene and blamed Ambien for his judgment or lack of judgment in fleeing the scene. But in this case, it's interesting, and I think most laws in most states require the prosecutor then, when there's an involuntary intoxication defense, to disprove it. So the state is under a double burden here, or a triple burden, really, if you think about the death penalty also being in play. You've got to prove the person's guilty. You've got to get the jury to decide, impose the ultimate punishment. But first, you have to disprove this nonsense of involuntary intoxication. And Stacey, in my opinion, that's all it is. This guy hunted these poor people down inside of his estranged wife's home for one reason only, because he was angry about the restraining order that she had taken out against him. And this is such a terrible commentary on what happens in these kinds of cases. Unfortunately, the act of going to court and getting a restraining order for protection can often be the impulse driver of the offender to then go and kill his victim. It's a terrible, terrible effect that happens sometimes when women seek the criminal justice system's help and they don't get it.
Let's go back to the Ambien defense. And you mentioned a case in which a congressman perhaps used this defense. He crashed his car. I mean, I could almost see this being believable in the case of a car accident or something. Obviously, when you're under the influence of a drug like that, it makes it very difficult to drive, and you're advised not to drive, in fact. But in a case like this, I mean, and I think about, Ambien just being in the news 2 weeks ago when Roseanne Barr, right, said that Ambien is what caused her to tweet the nasty racist tweet that led to her show being canceled. Obviously, a much lighter, much less serious offense and not a crime. But are you aware of cases where a true crime like murder has been acquitted because of a drug like Ambien?
No, I'm not aware of it being used successfully. And in the Roseanne Barr case, if you'll recall, Ambien actually took the extraordinary step of tweeting that taking Ambien doesn't turn you into a racist. And I would say that taking Ambien also doesn't turn you into a rage monster murderer, going hunting through a house, shooting through closed closet doors, breaking in and murdering a completely innocent person that had nothing to do with whatever was going on in his mind, and then seeking out and killing your estranged wife. There was one reason that Colley committed this crime, it looks to me like, and that was just rage. He was angry at his ex-wife for leaving him, his voicemails to her show that he wanted to get her back, and when she clearly wasn't going to go along, he decided to kill her. Bottom line.
You know, just going back to the Ambien thing once more, I expect this means we'll hear a lot of expert testimony about the drug from pharmaceutical and medical experts as both sides try to prove what this drug can and cannot do to a person.
You will, Stacey, and it's one of the unique things about death penalty cases is that there is a network of experts that defense attorneys use who all are in agreement that the death penalty is barbaric and should never be imposed in any case. And so they're willing to fly all over the country and even sometimes the world to testify in certain ways in these kinds of cases. So I suspect the defense will be able to find someone who will say that Ambien can turn you into a rage monster, but I'm not aware of any case where that defense has successfully been used.
Again, this isn't a case of whodunit, just like the Shawn Grate case that we revisited today. No one is really disputing that Colley committed these murders. The fact that he called his father told investigators he called him after and confessed to the crime, said, I shot my wife and his friend. Does that play a role if he's not disputing having done it anyway?
It does, and that's going to be key testimony for the prosecution, because having the defendant's own father be the one, and I admire him tremendously for coming forward and telling police that that is what happened, that he confessed to him, is going to be very difficult for that father. I don't know whether he'll recant or take back what he said, dispute somehow that he said it. I don't know if he's on recording telling police what his son said, but that's going to be key evidence because the prosecution will be able to present it as someone who has absolutely no motive to lie in a way that is getting his son into very hot water.
And I should add that Colley's father told police that his son, James Colley, was furious after the court hearing earlier that morning. So that certainly does not help the defense's case that you have the defendant's own father saying he was furious and in a fit of rage after the hearing.
No, and that is going to be a very key, critical piece of evidence for the prosecution. Those two pieces of evidence that the father brings that disputes or really completely discounts the Ambien defense, his confession and his being enraged by the wife, is going to be really, really critical evidence. And I suspect that the father is going to play a role that he never imagined having to play and is going to be very difficult for him. I feel a lot of sympathy for him.
Yeah, absolutely. That's a good point. And this is another case where we have two surviving victims, victims of attempted murder, essentially, who will be able to and who likely will testify about what they experienced that day and what they perceived to be James Colley's state of mind at the time of that shooting.
That's right, Stacey. You know, eyewitnesses to murders are actually pretty unusual. It doesn't really happen all that often where you've got murderers that are witnessed by somebody else. And in this case, you have two surviving witnesses, and they're going to bring that emotional punch, that emotional impact into the courtroom to bring the jury into those few minutes, the last few minutes of Amanda Colley's life, when they can describe their fear and their terror at being stalked and assaulted and having Colley try to murder them at the same time he was murdering the other two who didn't make it.
Yeah, well, it will certainly be an interesting trial. We will be there every step of the way. Again, jury selection now underway, expected to last about a week, and we could hear opening arguments on Monday. Francey, thanks so much for being with us this afternoon and giving us all of your expert analysis.
My pleasure, Stacey.
And thank you to all of our viewers for being with us this afternoon and watching. Coming up tomorrow, we have a new trial for you out of Georgia, and then Monday, the James Colley trial starts. We'll see you back here tomorrow morning. Have a great evening.